All right, council, I'm just waiting for Mr. Arndt to sign on here. So just 1 second. Oh, he just signed out. So council, I can just have you hold on for just a minute. Mr. Arndt was on and then he got disconnected. So hopefully it'll just be a minute or two.
All right.
No problem. We lost him again.
Yeah, it looks like he got disconnected again. I'll give him one more try here and then we'll see where we go. Here we go. Okay, Mr. Arndt, if you can just unmute. Okay, good. All right, we've got everybody. We'll go on the record now in this is Linville versus Alberts, case number 2113675. And if I could have council put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Matt Bates, appearing on behalf of the plaintiffs James and Margaret Linville.
Good afternoon, Your Honor. This is Dale Arndt appearing on behalf of defendant Timothy Alberts and Amber Rote.
And Richard Batchelder on behalf of defendant Homeowners Insurance Company.
All right, thank you. We're on the record here today for kind of a final status conference. We have some trial dates set for the middle of March. And just looking through the file, it looks like based on some motion practice we had there at the end of the summer that that's going to be with regard to the uninsured motorist benefits against homeowners. So this is just again a final status conference to see if there's anything else we need to address before those trial dates. On behalf of plaintiff, Mr. Bates, where are you guys at this point?
Right now, we're just working on getting trial depositions set to move forward.
Okay, from plaintiff side, are there going to be any motions in limine or anything else that we're going to need to address prior to the trial?
As far as motions in limine go, there's nothing glaring that I've got in my mind that really needs to be addressed from plaintiff's perspective.
Okay. Mr. Batchelder?
Sure. And Your Honor, you mentioned uninsured, but it's actually underinsured as far as the, yeah. I don't anticipate any motions in limine. One thing we had discussed before, and I don't know that we had any finality to it, was is that Mr. Arndt and his clients are not being, or they're not going to be a part of the trial. I anticipate it's an admitted liability case, so we'd be looking at damages. And the question that I asked before, and we talked about, we discuss it again today, would be in that regard, are the defendants going to be, for purposes of the trial, the identified defendants being Mr. Arndt's clients, or is it going to be Homeowners Insurance Company?
All right, counsel, do either of you want to weigh in on that? Mr. Bates or Mr. Arndt?
Well, my thoughts would be, it would be the insurance. I mean, we can name them, I guess, that they're a part of it, but it would still, because I mean, technically a conflict does exist there between auto owners and or homeowners and Mr. Alberts and Mr. Rote. So it wouldn't be appropriate to say we're trying it against them when it's actually homeowners.
Well, that's what we had. That's what the issue was before, because the court ruling was that Mr. Arndt did not need to participate in trial because he had offered policy limits, and then the issue becomes there's not really a conflict. They've offered their policy, and therefore, the issue is, do you name the insurance company and be concerned with a jury's inflation of an award because it's a dependent insurance company, or the initial parties are Mr. Arndt's clients, and should they be the named parties?
Here's my position, Your Honor.
I don't anticipate there'd be any testimony from them because of the admission of liability going into the trial.
Thank you, Mr. Arndt.
Yes, Your Honor. I don't believe that Mr. Alberts or Ms. Roach should in any way be named on any of the pleadings or discussed with respect to the defendant. This is a straight contract claim that we're not a party to, and we're not involved in these proceedings. We've been excused from these proceedings, so it's a direct contract claim that goes to homeowners, and they can explain the nature of the coverage and what coverage exists, and that takes it right under the contract, which is why we wanted to be and should have been out of the case.
All right, Mr. Batchelder, anything you wanted to say in response to Mr. Arndt's argument there?
No, I just think we need to have it clear before we move forward. And other than that, I think I mentioned, Your Honor, I don't have any anticipated motions in limine. It'd be nice to engage in any kind of negotiations, but that hasn't happened, and I guess we're pressing on to trial.
Okay, so my view, and I mean, this isn't, I guess, I don't know that it's how we would call it, or how would we refer to this as being postured for purposes of today's hearing. But my view on this is that, this is a claim that's been made by the plaintiff against homeowners, and so it should be homeowners as the named party. Certainly, with the input of counsel, I'd be willing to look at some type of jury instruction, Mr. Batchelder, to alleviate any prejudice that might have against your client in terms of a jury. Maybe that's appropriate, maybe it's not, but I certainly would be willing to consider it. But in terms of how the case is presented to the jury, I mean, again, this is clearly a claim by the plaintiffs against homeowners, and so it should be postured that way in terms of the pleadings. So that's my view on that.
All right, and just there is a jury instruction that addresses that issue, Your Honor.
Okay.
So, yeah.
All right. So I guess what I'd like to do then is set up a conference call, maybe 5 to 7 days prior to the trial date with counsel, just to address any final matters that we need to discuss. And just to make sure that we are actually going to go forward with the trial as scheduled. I anticipate, a lot of times there's last minute negotiations that go on. So my office will set that up with counsel. I would like prior to that time for both counsel to exchange their final witness and exhibit lists, and then for counsel to submit their proposed jury instructions to the court. So that we can all have exchanged all those documents by the time we have that final phone conference.
All right. Your Honor, there is an issue, and I sort of addressed this with Mr. Bates. I have another trial starting in Cadillac on March 5th. It's likely going to be about a 2-week trial. And right now, I'm not a major player in it, but my client's involved. The parties are quite a ways apart, and one of the depositions he has scheduled was March 14th. Now, I anticipate I'll be in trial on that day. If the trial begins, there's a settlement conference on that case on Monday. So I just wanted to put that out there. There are potential for having some conflicts moving forward with the trial preparation.
I'm trying to see if I can find additional dates, but these are all doctors out of U of M Ann Arbor, and scheduling with them is an absolute nightmare. They, for whatever reason, I have to go through their lawyers to get anything scheduled. If it was a normal doctor, just these doctors that for some reason, they won't even talk to me. It's insane to me, but I'll try to do everything I can. But that was the only date that they would tell me as of now that they were available.
All right, and I'm just going to ask counsel to continue to work towards being prepared for trial. To the extent there are issues, then whichever side has those issues, we'll just need to address that by motion. Otherwise, I'm just going to plan on having those trial dates set as they are.
Okay. And Your Honor, as far as that goes, if I'm involved in this other trial, do you require trial counsel to be present, for example, on the phone conference we're going to have before the trial, or any of those motions?
No, as long as somebody's there that can, give definite answers and participate meaningfully in that conference, that's fine with me.
Okay, thank you.
Okay.
As for Judge, just for clarification on the witness and exhibit list, do you want them just exchanged at any point prior to this conference, or is there a particular date you were going to set?
No, just prior to that conference. And again, I'll send out a notice of the date and time for that. And so you guys will have that date to work with. So yeah, just exchange those and provide it to the court. So I've got a copy, and same with the proposed instructions and verdict form.
Okay.
And I'll put what we talked about here today into a status conference order and send that out as well.
Okay.
Okay.
All right, Mr. Bates, anything else I can address for your side today?
No, Your Honor.
Mr. Batchelder?
No, other than if they want to make a demand, I'll certainly pass it on.
What? And I will say I conveyed your offer to my clients, and I said we can, 300 is our current demand is 300,000, and I asked them to move off of it. They weren't thrilled with the offer, and told me they didn't want to extend a different one.
All right. Well, that offer was trying to get the ball rolling, and I know you understand that, but
I do. I'm not trying to be. Of course, we've all got different. I don't want to waste anyone's time or money. Absolutely.
All right. Okay. Appreciate it.
Okay. That's all I have for today. Thank you, everyone, and all counsel are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
Okay, looks like we have council connected, so we'll go on the record in Beckwith versus Spink. This is case number 2314111. And if I could have both council put your appearances on, starting with plaintiff, please.
Mike Corcoran on behalf of the plaintiff, Your Honor.
Good afternoon, Your Honor. Attorney David Gilbert praying on behalf of defendant Miss Spinks. Miss Spink is here via Zoom also.
All right, thank you. We're on the record today for purposes of a status conference. It looks like the last hearing we held was back in October. And at that point, I believe, at least as of the date of that hearing, Ms. Spink wasn't represented. It looks like the appearance was filed after that, but she had previously, a default had been entered by Mr. Corcoran. So I guess I want to see where we're at and where we need to go with this. Mr. Corcoran, on behalf of plaintiff, can you address that first?
Yes, Your Honor. I've scheduled a motion for default judgment hearing on March 5th at 2:30 via Zoom. I sent a copy of that to your assistant today and to Mr. Gilbert via email. I will file the original tomorrow in Kalkaska when I'm up there and provide a court a copy via mail as well. So that's the status.
All right, thank you. So Mr. Gilbert, I assume you'll contest that motion.
We will, Your Honor. There's a couple things that go along with this file. Originally, Mr. West was part of the case, and I think we have a couple of different files. Ms. Spink says that she wasn't served until we got some other paperwork. I have yet to receive any paperwork from Mr. Corcoran. However, the underlying issue with this is this has already been tried. Mr. West brought it up in a previous trial, stated that he had sublet the storage to this plaintiff that was outside of any contractual relationship with Ms. Spink. Then in that trial, Judge Power ruled that Mr. West had a certain period of time. He was ordered to get his possessions or vacate the storage unit, which Mr. West failed to do. And apparently he had also some of this plaintiff's material in there. So this has already been ruled on once. And then originally, because the case, I believe, was filed with Mr. West, there's an appeal ongoing on the underlying case. So I'm a little bit confused as to what the nature of this case is. However, I'd ask that Mr. Corcoran forward all the pleadings so that we may respond appropriately.
Glad to do it, Your Honor. I don't want to argue the case right now, but I'll be glad to send him the complaint. I sent him the motion and an affidavit of Glenn Beckwith today, but I'll make sure that he has it all and he can make his argument. So.
Okay. All right, fair enough. So we'll proceed with that motion as scheduled in March, and then we'll see where we go from there.
Okay.
Mr. Corcoran, anything further for the record today from your side?
Nothing further.
Mr. Gilbert.
Nothing from defense counsel. Thank you.
Okay, thank you. We'll see you in March. Parties on this case are free to disconnect. Okay, looks like
There
we
we
have both
go.
counsel connected. We'll go on the record in Bishop versus Cecil. This is case number 2314275. Pardon me, if I could have counsel put your appearances on, starting with plaintiff, please.
Jeffrey Alot, on behalf of Mrs. Bishop, plaintiff, Your Honor.
And Abigail Bosco on behalf of Justin Cecil and Matrix Evolutions, the defendants, Your Honor.
All right, thank you. We're on the record here today for a status conference. Looking through the file, I know that parties were working on mediation. It looks like you do have a mediation set for later this month on the 21st. So I don't know if there's much we need to do today other than set it for another status conference, maybe following that mediation.
Yeah, I tend to agree, Judge. I think we wait and see how mediation goes.
Yes, Your Honor, if I may, I believe that we should set it for a subsequent status conference. And if the case settles, we'll submit the appropriate documents.
Okay. Anything else I can address for either of you while we're on the record here today?
Nothing
I don't
from me,
think
Your
so,
Honor.
Judge.
Okay. All right. Thanks for your time this afternoon, counsel. You're both free to disconnect.
Thank you.
Okay, thank you, Your Honor.
All right, looks like we've got both council connected. So let's see, Mr. Zayas, if I could have you unmute.
Afternoon, Your
Okay.
Honor.
All right, good afternoon. We're on the record now in Kaywood versus Cook, and this is file number 2314307. And if I could have both counsel just put your appearances on, starting with plaintiff, please.
Joseph Zayas on behalf of all the plaintiffs, Your Honor.
James Alcucci on behalf of Ed Cook.
All right, thank you. We're on the record here today for a few reasons. Number one, we've got a couple of motions up. Let's see, we've got defendant's motion for summary disposition and plaintiff's motion for a preliminary injunction. I did receive the filings of both sides. I've had a chance to review the briefs and supporting documents. I'd like to start with the motion for summary disposition. And so, Mr. Kocha, did you want to proceed with your oral argument on that motion?
Yes, Your Honor. I'd also mention to the court that Amy Cook is also on the screen here. She's on my lowest part of the screen there. Maybe she should identify herself as being here as well. I don't know if she has anything to say, but she's here on screen. So,
all right, I typically, on a motion hearing like this, I typically wouldn't hear from the parties unless they were directly participating. So if you just want to go forward with your oral argument.
Very good. Thank you, Your Honor. This is our motion for summary disposition pursuant to MCR 2.116C8. I have filed the motion and also a brief in support of the motion. The brief dated November 22 of 2023. I'd incorporate that filing also by reference into my argument. The long and short of our motion, Your Honor, is that plaintiffs have not sued the owners of the property. They've sued the defendants, Ed Cook and Amy Cook, again, who are not owners. Ed, my client, is a son of a decedent, former joint tenant of the property. And Amy Cook is the widow of one of the former owners, who also was Ed Cook's father. Plaintiffs admit in their unverified complaint that Ed Cook, Amy Cook are not owners of Lot 28. That's the lot over which plaintiffs have claimed adverse possession. And our position, long and short of it, is that without naming and bringing into play the owners of the property as parties to this, then there can be no adverse possession found against these people who are named as the defendants. They are not, nor have they ever been, owners of the property, lot 28. Plaintiffs have known that at the time of the filing of their complaint. They admit that these defendants are not owners of the property in their complaint that they filed. They've even attached to, the plaintiffs have even attached to their complaint a copy of the deed showing the owners of the property. And again, neither of the defendants that are named here are the owners of that. So without the owners being named and brought into a lawsuit for adverse possession, because it's those folks or the owners of the property against whom the complaint should be made, there is no case here. The plaintiffs have failed to state a cause of action for which relief can be granted here under C8. Their complaint for adverse possession, prescriptive easement, or otherwise, acquiescence should rightly fail. If they cannot prove any of this, then they're also not able to prove or establish any trespass, because they're not able to show, plaintiffs are unable to show against the owners of the property that there has been, that what property belongs to whom? Is lot 28 encroached? Is there some of lot 28 that belongs or should belong to by one of these claims of plaintiffs to them? They just can't say that. There's no defendant here that's in a position to defend necessarily the complaint of plaintiff, and therefore their complaint fails. In the complaint itself, Your Honor, in their brief rather, it says in the response to my motion, it says, while it is true that plaintiffs must prove that they are the owners of the property as part of their case, and they can't do that. There's no way to do that here, because the party that should be defending and saying, we own the property, we object to the complaint, we object to your claim, they're not here. They're not part of this lawsuit. They're not able to prove a prescriptive easement, which count 2 of the complaint says. Because of the failure of the plaintiffs here to name the proper owner or owners of lot 28. In essence, what plaintiffs are saying is, Judge, our claim should stand. My motion for summary disposition should fail because we say we are the owners of this disputed property, period. And again, Judge, that doesn't rise to the clear and cogent proof and so on that is required for any of these claims they're making, because they haven't named the proper owners of the complaint. It's interesting to me, Your Honor, that they say that this property has been in use by them for probably 60 years, or their predecessors, interest, family members, and so on of them. But they wait until all the owners have died before they bring any sort of a claim at all. Just is curious why that is. What the plaintiffs are relying on is possession or control. They say that's sufficient for us to be able to demonstrate adverse possession, acquiescence, prescriptive easement, and the like. And again, that is not what the case law shows. You've got to be an owner in order to be able to have these claims made against you. Now, let's just suppose for a moment that the court would say, yeah, this case can go forward. Again, I dispute that. But what's the remedy? You're going to find that the plaintiffs adversely possessed against Ed Cook. What does that mean? The owners say, well, it's still my property. It won't matter because it's not going to affect the owners. If you say there's a prescriptive easement against Ed Cook or Amy Cook, or that there's acquiescence by them, what good does that do? Because it's not affecting the owners of the property because they're not parties to this lawsuit. So as a matter of fact, Your Honor, again, I think in the response here to the motion from plaintiffs, they really don't even challenge that. They're not challenging that. They're not challenging that these folks that are named as defendants, they haven't argued that, oh, we haven't named the owners and therefore this complaint should stand. There's, well, this just that they were there, just that they somehow control the property, whatever that may mean, is sufficient and clearly, in my estimation, and what I've found and what I've put in my brief and so on, do not. So if they do not have a claim, the plaintiffs do not have a claim if they do not own or have an easement against these particular defendants. They don't have a claim because they can't establish adverse possession, prescriptive easement, or otherwise. And if they cannot do that, then their complaint should fail. What plaintiffs have done here, Your Honor, is basically build their complaint on use a house of cards, and the house of cards has as its base the use of a piece of property by certain individuals, the defendants named here. But again, they are not the owners. So if you pull that base away, you take that out, the whole complaint crumbles. Whether it is this is our property, we get to expand lot 29 over into lot 28, whether it is for preliminary injunction, for any reason whatsoever, their house of cards comes tumbling down because they've not named the proper defendant. So again, the plaintiffs have known this. They say that in their complaint multiple times. These are not the owners. They acknowledge that. They say that again in their responsive brief to me, that they have the obligation to prove who the owners are and that they adversely possessed against the owners without naming and without joining the owners. I think that this complaint should be dismissed under C8. They also think, Your Honor, because they haven't taken the time to go and track down one way or another, or name the owners, or say whomever the owners happen to be, publish or whatever they've got to do, what remedy they have to find the correct owners, that this complaint's been filed in bad faith. And I think that sanctions should be awarded in favor of my client and against the plaintiffs here because they've acted in bad faith under MCR 1.109. I believe it's E5. It's for harassments. It's for other purposes that don't fall within a proper filing here. And so we'd ask the court to dismiss the complaint that's been filed. And if plaintiffs do have a claim against anyone on this, it's the rightful owners of Lot 28, and then they can take up their cause again at a later date. Thank you.
All right, thank you, Mr. Zayas.
Thank you, Your Honor. Wow, to know where to start. I guess my first thought is if either counsel or the court wants to know why we waited till now to file suit, is because these defendants caused spikes to be put in my client's driveway, metal spikes. When we said, no, wait a minute, that's our property, they built a fence. When we said, hey, let's talk about this, they cut down a tree that my client's great-grandfather planted on their property. All of those things, Your Honor, are trespassing. All of them are trespassing. The only way counsel's argument would be correct is if I brought a quiet title action to try to claim the property. The quiet title action to actually trigger a judgment saying that's ours. That's not what I did. I sued them for trespassing. Now, a judicial action, the case law is very clear with both an easement and adverse possession that you don't need to bring a judicial action for fact title. At the expiration of 15 years, that vests. It's your property. That's the Gorday case that I cite in my brief. That's 202 Mishap 161. And that's the Morlett Auto Wash case that I also cite in my brief. That's 501 Mish 192. At the end of that 15-year period, that's becomes their property. Now, do we have to prove that? Yeah, we have to prove it. But this is a C8 motion, which means you have to take each and every allegation in our complaint as true. That means you have to take it as true for the purposes of this motion that my client maintained, improved, and occupied that property in an adverse manner for a period of 15 years. At that point, it became ours. It became my client's property. And they have the right to take any action that's legal to defend that property. Meaning that if somebody trespasses on their property, they have every right to bring a trespass action against their property. It is against those individuals for both damages and injunctive relief. It is simply flat out wrong to say that we need to somehow list the owner of the adjacent property, whomever that is. As what is strange is that defendants haven't been fully cooperative in saying, hey, no, this is the actual owner. They're kind of hiding behind that fact. But it's flat out wrong to say that we have to name that owner of that edge of the adjacent property in order to get relief for trespassing. If that were true, then we wouldn't be able to bring any claim against any third party to defend our property at all. To say that these individuals can trespass on our property, can plant spikes, can build a fence, can cut down a tree on our property because they don't own the adjacent parcel, that's not the law. It absolutely is not the law under any stretch of the imagination. Now, do we have to prove that it's our property? Yeah. But you don't need to name the owner of the adjacent property to prove that. Why would you have to do that? We can absolutely prove that in this case, and we will prove it. But for the purposes of this motion, you have to take the allegations as stated in the complaint as true. Meaning you have to take it as true that they trespassed on our property and did damage. We absolutely stated a claim for trespass, and we absolutely stated a claim for interference with an easement. And to say that they get to do whatever they want on our property, and it became our property at the expiration of 15 years, because they don't own the adjacent parcel?
Well, Mr. Zayas, let me ask you a question about that.
Sure.
I mean, I understand your argument that at the expiration of the 15-year period, that title vests. But how does that, I mean, how would anybody know that your clients own that property? How would anybody in the world know that your clients own that property after that 15?
I apologize.
I mean, isn't that why we have quiet title actions, so that you can get a judgment from a court that says this is your client's property, and you record that, and that puts the rest of the world on notice that that's your client's property, and therefore, if somebody does trespass on it, then they would be liable for knowingly entering onto the property of someone else. So if you just say this is our property and it became our property 15 years ago, you know that, I guess, your clients are saying that, but how does anybody else in the world know that that's their property and that they can't go on it? Especially if the other person has a deed that says it's their property.
Well, first of all, they don't have a deed that says it's their property because he's not the owner. So he has no property rights here. Second, Your Honor, in a perfect world, we would absolutely sue the owner of the adjacent parcel and get it.
Okay, I'm not asking about a perfect world. I'm asking you to answer my question, which is, if your argument is correct and that property just automatically became your client's at the expiration of that 15-year period that your clients say started at a particular time and ended at a particular time, how does anybody else in the world know that that's now your client's property and they can't enter onto it?
3 reasons, Your Honor. First, because we told them. We sent them a letter saying this is our property and you shouldn't enter onto it, and they responded by building a fence.
How about just a random person that you didn't tell that to and who came on that property? Or what about when they did it, when they put the spikes in the first time? How did they know that putting those spikes in, that they were doing that on your client's property?
Well, the second reason, Your Honor, because the driveway and the path down to the lake and that property has been improved and maintained by my clients since my client's great-grandparents started going to the property in the 1960s. So by observation, you can see that my clients have been taking possession of that property for the statutory period. So by observation, you can also do that. And I'd also add, Your Honor, that would be a question of fact as to whether or not he had knowledge or not, and whether or not it was an intentional trespass, particularly before we sent the letter. This is a C8 motion. And for the purpose of a C8 motion, I think you have to take, you have to take the allegations as stated in the complaint, which is that he intentionally trespassed on our property. So I can see that being an issue later on, but I think by observation, by the fact that we improved and maintained that property for 15 years, and the testimony will bear that out. And certainly after we sent him the letter saying, you can't put stakes there because that's our property, and he responded by building a fence there, that he had the requisite knowledge to back off and was liable for any damage that occurred to that property.
Okay, what about anybody else in the world? What if somebody were to buy lot 28? There's nothing in the chain of title that says that that strip belongs to your client. So how would somebody purchasing that property know that that now, as of the expiration of that 15-year period, now belongs to your clients and they own it?
Sure. So again, that third party, several things, Your Honor. First of all, for trespassing, the intent doesn't have to be to trespass. It has to be wrongfully on the property. But that being said, you're right. If a third party with no knowledge just wandered onto the property, there would be a discussion that took place. Would that amount to trespassing? I'm not sure. But there would be discussion that took place that said, hey, this is our property and here's why. And if they continued after that by cutting down trees and building a fence, then that would arise to the level certainly of trespassing.
So all your clients have to do is say to anybody who might come on that strip of property is say, hey, we've been exercising control over this property for 15 years. It became ours in 1980, whatever. And you can't come on this property now. And that's all they have to do to make that property theirs and to prevent anyone else from ever entering onto that property.
Well, it doesn't make it theirs, Your Honor. It becomes theirs at the expiration of 15 years. And then it becomes a question of fact for this court to decide whether or not that property was theirs or not, and whether or not the plaintiffs can prove all the elements of adverse possession or not. Just saying it's ours doesn't make it ours. We have to show the elements of adverse possession. That's true. But after showing the elements of adverse possession, and after fulfilling, I should say not showing, but fulfilling the elements of adverse possession for that period of 15 years, under the Gorte case and under the Morlow Auto Wash case, that title vests and it becomes ours. And if title vests, that means you have the right to take any and all action consistent with property rights, meaning asking people to leave, meaning bringing trespass actions if they don't.
Okay, but the only way for anybody to find out that is for your clients to tell them that.
Well, they would also be able to find out by observation through observing that they have actually improved and maintained this property. But yes, there would be.
There's no document or anything that anybody could go to find out that that property belongs to your clients. They have to rely on your client's word and their own observations to know that that property belongs to your clients and has since that 15-year period ended.
No, there's not a recorded document that says that, Your Honor. That's true. But again,
can you see how that's a really difficult argument to make, that your clients can claim this strip of property and just say, all we need to do is say that it's ours because we say that the 15-year period ended and no one else can, there's no other way for anybody to find that out other than by asking us?
That's not the case, Your Honor. One, this is a C8 motion, so you have to take the allegations as stated here. Second, we have to prove all the elements of adverse possession. We have to prove that we maintained it at the end of this case, but we're not there yet. We're not saying, court, Your Honor, please take our word for it, it's ours. We have to go through the process and prove it's ours. I understand that, but this is a C8 motion. And for the purposes of a C8 motion, you have to take the allegations in the complaint as stated.
Okay. All right. Thank you. I think I understand your argument. I appreciate your answers to my questions. Anything else that you wanted to say for in defense of the motion?
No, Your Honor. Thank you.
Thank you. Mr. Kocha, it's your motion. Anything that you wanted to say in response?
Sure, Your Honor. If I may briefly, again, the way for this to be resolved, for them to prove their case, and maybe for them to have their facts accepted, would be to deal with the owners, not with some third party non-owner of the property, which they admit. Also, the court should look at within their filings that they've made to this point. The plaintiffs have identified not only what I've referenced before, but also that this is a shared, not exclusive, not hostile. I've given but shared path. So in those circumstances, I find it hard, and counsel has been harping on adverse possession. Well, shared doesn't mean hostile at all either. So that the owners are not here to defend, and we believe as well that there's not a claim here until these elements have been proven, until there is some order of the court that says this property or this portion of lot 28 belongs to plaintiffs, that there is adverse possession. It is not just because plaintiffs say so. It is because a court has determined that, or there's been a stipulation between the parties or otherwise. So again, Your Honor, we believe that this motion should be granted, that plaintiff's complaint should be dismissed.
All right, thank you. I did have a chance again to review the briefs of the parties on this issue. And looking at this under the standard of a C8, which I believe both sides appropriately cited the correct standard in their briefs, and the court adopts that as the standard of review under a C8 motion. And I think one of the important things to acknowledge here, and Mr. Zayas points this out in his response, is the claims that are pled here are for trespass. They're not for adverse possession in and of themselves, or acquiescence, or for prescriptive easement. So the claims that are pled are trespasses. And as Mr. Zayas also correctly pointed out, one of the elements that they have to show for trespass is that his clients have the right to possession or title interest or some type of interest contrary to anybody else in that property. And the way that I read the complaint, and the way I understand it as it's been argued here today, is that that right is based on a theory either of adverse possession or acquiescence or prescriptive easement. And so in essence, what I view the plaintiffs are attempting to do in this case is to use a theory of adverse possession or doctrine of acquiescence or prescriptive easement as a way to prove one of the elements of trespass. And the problem I see with that is that, in essence, they've got to, as an element of proving their trespass claim, they have to establish adverse possession or acquiescence or prescriptive easement. In other words, they're essentially trying to bootstrap or side door a quiet title action in by making it or posturing it as a way to prove one of the elements of trespass. And part of the problem I see with that is I think case law is very clear that to prove adverse possession or acquiescence or prescriptive easement, that proper parties or proper defendants in an action like that are the owners or record title owners or those with possessory interest in the property in question. And that's because one of the elements, particularly of adverse possession or prescriptive easement, that has to be proven is that element of hostility, that property was used in a way that's inconsistent with the rights of the owners or without permission given or asked of the owners. And so again, it brings us back to, in order to prove one of the elements of trespass, the plaintiffs have to establish that they're entitled to that property. And in order to do that, I think they need to have the record owners in there, again, because those are the rightful defendants of an action for adverse possession or acquiescence or prescriptive easement. And I read the cases that Mr. Zayas cited, and I just don't agree with his interpretation there. I don't think either of those cases stand for the proposition that you can get title to property or ownership of property without some kind of judicial action. And again, I say that because the whole point of a quiet title action is to get a judgment from a court that says, this is my client's property. That gets recorded in the chain of title, and it puts everyone in the world on notice then that property belongs to my clients. And then anyone who acts inconsistent with that is subject to a claim for trespass. To argue that somehow they get title or ownership automatically and no one else in the world knows that except their clients, unless they happen to live next to their clients long enough to observe it, and I guess, come to the conclusion that somehow, they've obtained title to that by adverse possession or whatever. That to me, that just doesn't follow. And to me, the ruling in the cases cited by Mr. Gordy in terms of vesting title, I totally agree with that ruling. And I think those rulings are correct, but especially Gordy, when you look at that case, that involved, statutes that were passed at a particular time that eliminated the ability to get title by adverse possession. And so the question is, well, when did that actually vest? And the court said, well, title vested at the expiration of that 15-year period. So it doesn't matter what happened after that, because that's when title vested. But I think that's a completely different question than saying, you know, they don't, that those folks that when their title vests, that somehow they're just automatically the owners, and they don't have to go through any kind of judicial process to put other people on notice if they're going to try and file a trespass claim. So I don't think those rulings stand for what plaintiffs arguing they stand for under the circumstances in this case. And so I think that where that leaves the plaintiffs is, I don't think they can bring a trespass action as pled, because again, I don't think they can establish adverse possession, acquiescence, or a prescriptive easement without first, again, bringing that action against the record title owners to show that hostility, to show the elements that they need to show in order to do that. Because otherwise the court would essentially have to rule that the plaintiffs acquired title to the property and do that without involving the people who actually own the property. And so again, I just don't think there's any case law that supports that kind of process. So the court is going to grant the motion under C8, because I don't think they can state a claim for trespass without first quieting title and establishing that they have title to that property. However, under 2.116I5, the court should allow, unless it would be futile, which in this case, I absolutely don't think it's futile, the plaintiffs the opportunity to amend their complaint. And I think that's what needs to happen here. I think that the plaintiffs need to plead a claim for quiet title against the owners here. If they can establish adverse possession or establish title to that strip by the doctrine of acquiescence or prescriptive easement as against the owners, then I think they can go forward on claims for trespass against these defendants. So the court is going to grant the motion pursuant to C8. The court is going to grant the plaintiffs 90 days to amend their complaint. And Mr. Kocha, I would ask that you submit an order reflecting that ruling of the court today under the 7-day rule.
Thank you, Your Honor. I will do that.
All right, and then Mr. Zayas, our next matter is your motion for a preliminary injunction. I did have a chance to read your brief as well as the response. Is there anything that you wanted to say in support of your motion?
Not given the court's ruling, Your Honor, I think it's, well, not given the court's ruling, Your Honor.
All right, Mr. Kocha.
I'm sorry, I didn't catch all of what Mr. Zayas said. Is he speaking to it, or is he withdrawing it, or I'm not sure. I don't want to speak to it if the motion's been withdrawn. I just didn't hear what he said.
I rely on my brief, and given the court's ruling, I don't have anything to add to what I've already filed.
All right, thank you, Mr. Kocha.
Your Honor, I'd ask for the motion to be denied in part because of the reasoning that the court has given in its earlier order here. Moreover, I don't believe that there's any showing of the elements for which the court would have to consider for purposes of granting a preliminary injunction. Beyond that, Your Honor, and this is more procedural than legal here necessarily, but as the court will recall, I filed a limited appearance on behalf of Mr. Cook, on Ed Cook's behalf. I did not receive timely notice because there was no notice given directly to Mr. Cook regarding this motion. My understanding is also that there's no notice of this motion for preliminary injunction given at all to Amy Cook. And so I received this motion, I believe it was yesterday, by email, or a couple days ago, maybe 3-4 days ago even, but there wasn't timely notice of the motion. So for that reason, it should be denied or set aside to a different day. My limited appearance, I have filed a response, and so for that, I've done that with my client's permission to do so, without having extended my limited appearance. I will offer the court that my limited appearance, if allowed, can be expanded to cover this motion as well. But the issues here, Your Honor, is that again, as my House of Cards reference, I don't see that they can ask for a preliminary injunction for something that still has not been established in any respect. So I'd ask that the motion be denied.
All right, Mr. Zayas, anything you wanted to say in response?
The motion was emailed to council 7 days prior to the hearing. It was emailed on the same day as the answer, and the fact that he filed a response on, which would have been last Tuesday, he filed a response on Friday, also via email, kind of contradicts his argument that he only received it 3-4 days ago when he filed a response 3-4 days ago. So the motion is timely. I'll rely on the arguments made in the brief. I think there is a danger for irreparable harm given what's already occurred. There's a serious danger of, more harm. There's already been a willow tree that was planted by my client's great grandfather, just ruthlessly cut down in this case. And I think, especially given the fact that there really is no property interest on behalf of defendants to weigh against my client's property interest, certainly weighs in favor of my client. But again, given the court's prior ruling, I will rely on preserve those arguments made in my brief.
All right, thank you. I did, again, have a chance to review the written arguments of the parties. I'm familiar with the facts of the case, obviously. Looking at the request for a preliminary injunction, injunctive relief is an extraordinary remedy. The court has to look at a number of different factors, which were properly cited in the brief, in terms of whether or not injunctive relief is appropriate. I think one of the factors that's often overlooked, and the court notes, again, under pretty solid case law, that those are not requirements that the court has to find are met. Rather, those are factors for the court to look at. But one that the court also finds appropriate is, particularly in this case, that's sometimes overlooked, and parties get hung up on the issue of who's ultimately going to prevail or whether or not there's a danger for immediate and irreparable harm, is a desire to preserve the status quo until all the rights of the parties can be adequately adjudicated. And in this case, I think that's the most controlling factor, particularly given that there's already been some actions by the defendants in this case in terms of what they've done on that strip of property. I think despite the court's prior ruling, if the record owners are brought in here and if the plaintiffs can prove the kind of facts that they've pled, I think there certainly is a potential that they could prevail on an adverse possession or doctrine of acquiescence case here. I think the desire to preserve the status quo and prohibit the defendants from engaging in further activity on this property, which I think is only going to lead to more issues, and if the plaintiffs do ultimately prevail, could be prejudicial to the rights of the plaintiffs. I do think it's appropriate, again, for the purpose of maintaining the status quo until this can all be hammered out. In the interest of justice, I think there should be an order maintaining the status quo. I don't think that at this point the plaintiffs would be entitled to have the fence removed or anything removed that's already been done. But again, I think in order prohibiting anything further from happening on that stretch by either side is appropriate. So the court is going to grant the motion for a preliminary injunction in that neither side may take any actions to alter, improve, change, cut down, do any kind of action in the disputed strip of property until this matter is fully adjudicated. So Mr. Zayas, if you would prepare an order that reflects that ruling of the court and submit that under the 7-day rule. So in essence, the parties have to maintain the status quo, both sides, as to this disputed strip. Mr. Zayas, anything further from your side for the record today?
No, Your Honor.
Mr. Coach, anything further from your side?
No, Your Honor, thank you.
Okay. All right. Thank you. That's all for today, and all parties are free to disconnect at this time. 20 minutes till the last. All right, looks like we've got all counsel connected, so we'll go on the record here. I'm just going to abbreviate the case caption because we've got so much going on, but Graciano versus Two Spokes. This is case number 2314241. And if I could have all counsel put your appearances on, starting with the original plaintiff, please.
Good afternoon, Your Honor. Robert Wims appearing for Giros, and hello to all the other gentlemen on the Zoom.
Good morning, Your Honor. Attorney Maniv Ahmad on behalf of defendants, Two Spokes. And good afternoon to everyone else.
Good afternoon, Your Honor. Good afternoon, counsel. John Grogan on behalf of Schwab.
Good afternoon, Your Honor and counsel. Greg Light here on behalf of State Savings Bank.
All right, thank you. We're on the record here today for two different matters. Number one, Mr. Wims filed a motion to compel. I believe that's only directed at Two Spokes. And then we have it set just for a status conference as well. I did not get any responsive pleadings to Mr. Wims' motion from Two Spokes, but Mr. Wims, was there anything you wanted to state in support of your motion?
Yes, Your Honor. I guess I'll try to make it really short as I can, because I know these are your favorite motions. I say that tongue in cheek, of course, because of the details. But I also know you did your homework. The bottom line is they just want our discovery, and I want a little bit of sanctions here. And let me tell you how it is. The first set of interrogatories was basically entirely targeted at their countercomplaint. In other words, you guys allege this stuff, and I'll just go for number one. It was, hey, tell us how you contacted, because they say in their countercomplaint that Two Spokes directly contacted my guy, Giros. So I basically kind of asked about the details. How did you do that? You know, do you have text copies, date, time, place, all that jazz? And what we got, and literally for almost every one of these, was the largest set of filibuster and objections. If it was organic matter, it would cover all of my cornfields, and I would be able to fill them all, and it would grow greatly, because not a bit of it was worth a darn, quite frankly. And there was no answers. We talk about, we talked to somebody else. We talked to a third-party defendant they drug in. Number three, the other one another one I wanted help on was direct contact, because they said in their countercomplaint, they contacted Giros again. I get the filibuster, I get the objections, I get no discovery on that. And again, it goes on with Teams Bob. I asked him about poor workmanship in number 7. I asked him about their damage claims, and I get the filibuster stuff. And we're trying to get work done here. We're busy. You're busy. I'm busy. So are Mr. Light and Mr. Grogan, and I'm sure Mr. Mott is too. But these aren't serious answers. We're not taking court seriously when we're giving this stuff, and we're not providing serious stuff. And then for request for documents, I ask for stuff like, hey, proof of, or the documents that you paid my guy directly. And I'm paraphrasing, of course, that you paid this third-party defendant directly, that you paid any other subcontractor directly, et cetera, et cetera. And I got bupkis. I got nothing. Now, I think it was Thursday sometime, he sent a 305-page document dump without any specificity. You know, the court rule requires them to be divided up, responsive to the respective request. Nothing, just 305 pages here. That's it. That's what I got. And I'm asking about their experts, their damage claims, and show me that. And then the last part was a bit about the initial disclosures, which were due last summer, excuse me, have not been filed. I brought it to their attention by motion. I brought it to their attention by an email. My associate did. Hey, where are you going to file? They still haven't filed their initial disclosures. And that's a pretty serious one. That's a court order that's been failed to comply. And he's had prompted at least twice my motion as well as the courtesy email before that. And we still don't have his initial disclosures, which, as you know, Judge, especially for a guy that's filed a counter complaint, they have to lay out their damage claims and how they got there and the documents. I got nothing. They have nothing. So what I'd like, quite frankly, I want you to please, I'd like you to strike their counterclaim completely, because I've asked about it and I've gotten stiff-armed, to put it nicely. Strike their affirmative defenses, strike their objections to my discovery request because none of them are, it's just that machine generated, here, have 500 words that don't mean a darn thing, and then I'll try to slip something in there. And that's not the way we practice law. That's not serious legal stuff. And I would like to supplement specific answers, or because many of them, for instance, where I ask, and I'll be candid, tell me where you've had direct contact with my client. I think the answer is almost certainly, well, now that you mention it, I haven't. But if you strike a counter complaint, all those go away. But otherwise, I want the specifics of those. Date, time, place, the method, just like my request asked for. And quite frankly, the other thing I want, because now there's people here, you spent time on it, and our brother lawyers, Greg and John are here. I'd like sanctions for this. I shouldn't have had to do this. This was months and weeks. I begged for this stuff. And I get, Thursday, a 305-page document dump and the same pile of organic matter we'll call objections. Thank you.
All right, thank you. Mr. Ahmad?
Your Honor, first of all, I did file a response. It was hand-delivered to the court, so I don't know why you may not have received it. But there was a lot for me to respond to in response to the oral argument. The response that I provided in my motion specifically talked about the information that was provided. They did request documents, but they did not comply with the discovery guidelines and rules. They issued approximately 39 interrogatories between the first and second interrogatories. Now, I responded very specifically to each subsection of each interrogatory, as I was required to do. Counsel is asking questions for which, if there is no documents, I can't produce them. I had reached out to my client's overseas. The 300-page document dump, I had my client specifically get all the text messages and give me all the text messages, which I printed out, compiled them in a PDF. The other documents that I provided to counsel already had them in their possession, Your Honor. They were attached to my complaint. When I draft my complaint, I'm pretty specific about the allegations and the information, and I attach exhibits to my complaint, which I did. In addition to that, counsel asked for information. For example, when did you have conversations with the plaintiff? Because our counter complaint did allege that. I did talk to my client. My client talked to them, tried calling them, reaching out to them. We don't have specifics. If a client doesn't have his phone, he doesn't have the phone records. I did provide text messages between my client as well as third-party plaintiff where there is communication in which it states, call Giros, call this person, and that's been provided. I understand I gave it to him on Thursday, and he's claiming it was a document dump, but a majority of those documents were text messages. As it pertains to Team Bob's and things like that, I provided all the documents that we had in our possession related to Team Bob's, Judge. I provided contact information for Team Bob's. We're talking about damages. I've explained to my client, I gotta go to the actual discovery because he's saying that I just made all these futile objections. I objected. I did put general objections, but then I also put additional objections about relevance and the court rule and how you're not supposed to ask more than a certain number pursuant to the court rule. We talked about the repairs in question 29. If you look at my response, and I'm looking at interrogatory number 1, I'm looking at subsection B. I object because I claimed it was irrelevant. He asked, the question was, did the repairs referenced in your paragraph 29 pertain solely to repairs made due to a vehicle crashing into the wall? I objected, said it's irrelevant, but I still answered. I directed him specifically to our third party and our counter complaint, which outlined the specific facts of what he was requesting. I also directed him to the contractual agreements that were part of the complaint. Your Honor, the fact that I also said the scope of work included repair work to the property resulting from a crash. The point is, yes, I did make objections, Your Honor. They weren't frivolous objections. I did respond based on the information I had. I did supplement those responses, albeit I haven't provided initial disclosures, but I intended to provide initial disclosures and my set of discovery out to everyone after we got to scheduling order, which was, we're having a scheduling conference today. I understand what the court rules say about the 14-day initial disclosures, but Your Honor, in all due fairness, notwithstanding the fact that the initial disclosures weren't provided, I specifically answered the interrogatories to the best of the information that was available. I specifically provided documentation that was in our possession, custody, and control. Brother counsel can also ask third-party defendant who the clients actually have a business relationship and get the information. This is an approximate $8,000 dispute that is now spiraling out of control, and we have tried. They did not complete their work, and we've specifically provided the information on what wasn't completed. We provide the scope of work, we provide the supporting documents, Your Honor. So to the best of the information we have, we've responded, I've produced them, and I understand brother counsel may not like my objections and may not like the nature of in which how I present the objections or whatnot. But Your Honor, I responded diligently to these answers. I will say one other thing, Your Honor, in my defense and credit to Mr. Wins. Brother counsel has worked on me in accommodating time to allow me to provide responses and information. I believe that I reciprocated in kind, but I would never not reciprocate in kind. He's been a professional and gentleman to me, and I don't have any personal issue. I'm just providing the information that I have, Your Honor. That's it.
All right, thank you. Mr. Light and Mr. Grogan, I'm assuming you guys don't really have a dog in this hunt either. Do you have anything to add?
No, thanks.
No, I would like to see the discovery, Your Honor. So I do share that opinion.
I did provide that to all parties, I believe. It was sent on that Thursday. I believe I copied you on it, but if I didn't, I'll be more than happy to make sure you.
No, I don't mean to confuse the issues. I was copied on the 305 pages. I just want to see the complete discovery. If there's anything else out there, I want to see it as well.
No problem.
It's
not an issue on my end.
All right, Mr. Wims, it's your motion. Anything you wanted to say in response?
Extremely brief. The exhibits to his counter complaint, things like letters that he wrote to me, those aren't evidence. I was asking for actual evidence from his client, not a nice letter that, again, brother counsel, good guy that he wrote me. That's not evidence. And also about the interrogatories, and we included that in our motion. Those are directly related pursuant to the staff comments and the federal rules of interpretation. We only asked, I think it was about 9 interrogatories, and the subparts were directly related, basically date, time, place. Do you have any evidence, or do you have any copies of stuff to back that up? In other words, they were all related. Those are single. And indeed, I think the procedure is, if counsel does object, is to contact the party that's propounded the discovery and then work it out. That didn't happen. And as it relates to text messages, I did go through, I believe it starts at page 146 of the 305 pages, and that's the rest of the discovery I got. And as far as I can tell, every text message is between his client, the defendant, and the third party defendant. There's no contacts with my guy. So again, in his counter complaint where he says I had direct contact, those all that should be stricken, because apparently none of it's true. And thank you. That's it.
Your Honor, may I briefly respond, please?
Sure.
First of all, I know brother counsel cites the federal rules for guidance. We're in Michigan court rules. Michigan court rules were clear regarding the number of interrogatories. Notwithstanding, I provided an answer. Talking about evidence, and he talked about letters that I provided. Letters that I provided specifically explained my client's position, Your Honor, which were echoed specifically in detail in the counter complaint, third party complaint, and again, reference to the exhibits. The third thing regarding the text messages, there is actually communication in the text messages between third party defendant and my client, where my client specifically stated, I called him, he didn't pick up. And third party defendant also said, yeah, he's not answering, things like that. Third, to have it stricken, my client's testimony, answers to interrogatories, the documents produced, all constitute evidence. And to say that we haven't provided responses or documents is not fair. And I know counsel might not like the form of the evidence that he's getting. But the fact of the matter, Your Honor, is I did respond very specifically, and my client will testify to these things as well. And at the end of discovery, if we have not met our burden under the legal standard, then the matter would be ripe for summary disposition or some sort of dispositive action. At this point, at this juncture, in light of the responses I provided, the specific objections I provided, the documents are provided, the evidence that's been provided, which also includes the pleading exhibits in the pleadings, I think it's inappropriate. I respectfully, if brother counsel, his opinion is that I haven't responded properly, and if Your Honor thinks I haven't responded properly, right, I will go ahead and I will supplement as specific as whatever, as much as I can, Your Honor, but I can't give and produce things that are not in my position. My client can't pull things and produce them if they're not in his possession. There was even subpoenas that went out by brother counsel, I believe, asking City of Kalkaska Health Department. But we didn't have those documents, but there's discovery, and you can obtain them through other means. So respectfully, Your Honor, that's my position. I'm a little concerned, though, Your Honor, that you didn't receive my response. I had a hand delivered by an attorney up there. And I know the court doesn't accept email pleadings, so that's I'll have to address that with my server.
Yeah, so I'm not sure. I asked the clerk because when I was.
I apologize. Was it Mr. Isles who delivered that?
Yes, he did. Hand delivery to the court.
He did get that. I do apologize. That was my fault.
All right, so we did get it, Mr. Ahmad. I didn't get it in time to read before the hearing today. But,
no problem. I think
I
think my oral argument echoed my response.
Okay, but it was received and it is filed. My clerk just notified me of that. Okay, so I had a chance to read through motion and look at the individual discovery requests that are at issue here and the responses. Number one, I don't think sanctions are appropriate at this point. It's my view of the way the court rules on discovery read and compelling discovery that sanctions aren't really appropriate until the court has ruled on a motion to compel. And then if a party fails to comply with the court's order coming out of a motion to compel, then the court can look at sanctions. So I think at this point, the court is not in a position, nor do I think it's appropriate at this stage of the case to impose any sanctions for any failures of two spokes to properly answer the discovery request. The court is going to order that the initial disclosures be provided within the next 30 days. Because I do believe that's something that is outstanding. In terms of the other discovery requests, again, I looked at each one of them individually in light of what the claims and counterclaims and cross claims are here. And it's my view that they are proper discovery requests. I viewed generally the responses to not be as responsive as they could have been and probably should have been in some cases. If two spokes doesn't have particular documents, then just put that in the response. I did find some of the responses to be kind of boilerplate type stuff. I think what we're looking for, and I agree with Mr. Wims, is things that are responsive that council can use. And so I think by and large, a lot of the responses either weren't sufficiently responsive or were just boilerplate kind of things directing council to other portions of pleadings when they should just provide the information. So the court is going to grant the motion. The court's going to order that the particular interrogatories and requests to produce identified by Mr. Wims in his motion be supplemented by two spokes within the next 30 days. To the extent that any of those requests are addressed by the documents that were submitted last Thursday that Mr. Wims referred to, then two spokes should identify which interrogatories or requests to produce that those documents would be responsive to. in lieu of filing a supplemental answer. If they've already provided those documents, in other words, as part of that group of documents, 300 pages, or then they can just identify, hey, X documents go to this particular discovery request. So the court's going to order that within 30 days. And again, no sanctions at this point.
Your Honor.
And Mr. Wims, I'll ask that you prepare an order that reflects that ruling and submit that to the court. Yes, Mr. Mott.
Your Honor, is that, so I want to make sure I'm understanding, because some of the, my understanding, recollection, some of the interrogatories that Mr. Wims has asked for, or responses for, is complaining about, exceed the court 25 limit for each party against the other party. And so am I to supplement in excess of that court rule, or am I supposed to supplement the first 25, Your Honor?
No, I find that Mr. Wims' requests were within the limits under Michigan law, so they all need to be responded to.
Okay, Your Honor, going forward then, is it my correct understanding that sub parts to the interrogatories, and I just want, for my own clarity, I can ask similar interrogatories with similar number to subparts to get the same information? Are we waiving that 25 limit that's inclusive of the subparts? And I'm not arguing with the court. I'm just asking because I just want to make sure that I'm going to comply moving forward also, because I'm going to have discovery responses requests as well. And what I want to avoid is a similar argument in that regard.
Yep, I understand, and I appreciate the question. My only answer to that question is I don't find Mr. Wims' request to be in excess of what's allowed under the court rules, and
okay,
yeah, that's all I can say.
Okay, I understand.
All right, going forward in terms of the status conference here, how do the parties want to move? I mean, obviously everybody's engaged in discovery at this point. What kind of cutoff do we want to set for that? I'll start with Mr. Wims.
Open to brother counsel suggestions, but I'd say somewhere between 120, 180 days, but you guys tell me, assuming the court doesn't object, what do y'all want?
That's what I was going to say.
Oh, okay.
I'm fine with that, Your Honor. I know there has been some recent preliminary settlement discussions between defendant and third party defendant. I know there's also been offers from plaintiff to defendant, trying to see if there's a global solution we can work out, but I understand that, you know, we move forward, attorney fees get incurred. I understand all that and I respect it. At this point, I don't object to the amount of discovery time that anyone's asking, but I do have a question. I'm not familiar with Kalkaska County attorneys, mediators up there, but is this something that would be worth an early mediation rather than moving forward on this and incurring fees? I know Mr. Wims is working very hard, as am I, to respect our respective clients, and I get it, but I'm trying to see if there's some way that we can do like some sort of early mediation. My client is overseas, and I am having conversations with them actively about this.
I personally,
might be looking at the claims here. I think mediation is, you know, early on might be helpful here. And in terms of mediators, typically I would leave it up to counsel, and I just what I'm hearing today, I think you probably could all work together, but to try to agree on a facilitator and identify that person, and then we would just set kind of a cutoff date for when we would all want to have that happen. So what do you guys think about that?
I'm fine with early mediation.
Okay. Like I said, I don't know anyone up there. Guys, we can talk, I guess, via email. You guys can float me some names and such, and we can go from there.
Okay.
And Your Honor, I've been sitting here quietly. We really don't have a dog in this fight. We were named because the bank has a mortgage on the property. I don't think there's any dispute that our mortgage has priority over any lien claim. The contract that was entered into in this case and the labor and materials that were provided post-dated our mortgage by, I think, about a year. So what I guess I would ask is, confirmation from the other council that we're all in agreement on that. And then if I could get dispensation from the court that, we can sit back and let these guys duke it out and, we wouldn't have to participate in mediation and that sort of thing.
Greg, we're going to send you our basic 1 or 2 questions about when was it done, history of payments, and then usually we allow it, depending on the answers, which I suspect would be, like you say, we just dismissal without prejudice is what we usually do. But I'll get answers under oath before I do that.
Okay, that's fine.
Mr. Ahmad or Mr. Grogan, either of you want to address that at all?
I would concur with the court and counsel. I think we need mediation as soon as possible in this case. Your Honor, it's one of those construction cases, and frequently the legal work involved, the nuts and bolts, can swallow quickly the little thing that we're arguing about. So I think the sooner the better. I'm fully in support of getting a local mediator, and I think we can handle it by email. I have no objection to the relief sought by Mr. Light. Thank you.
I have no objection, Your Honor.
Okay. All right, let's do this. Let's set 180 days for discovery. The court's going to order that mediation occur within 120 days. The court is going to ask all counsel confer and agree on a mediator within the next 14 days, and then notify the court in writing of the selection. I'm sure you guys can agree on one person to submit that to the court. And then to the extent that Mr. Light's involvement needs to be minimized or eliminated, I'll just ask counsel. It sounds like we've got agreement on that to submit a stipulation in order, which the court can sign. And I will put all of these things that we've just discussed into a scheduling order and send that out to you. And then the court will set this for a status conference again at about 180 days, right at the close of discovery. And then let's see where we're at that point. We could look at setting some cutoffs for dispositive motions, and then, see where we want to go in terms of scheduling from there. Mr. Wims, any other dates or scheduling issues I can address for your side?
Not that I can think of, Your Honor. Thank you very much.
All right, thank you. Mr. Ahmad?
No, Your Honor, you've been helpful. Thank you. I appreciate it.
All right, thank you. Mr. Grogan?
Thank you kindly. Good day, all.
Oh, actually, I do have one question, Your Honor. I'm sorry. Regarding service to the court, may I, in addition to serving the court clerk for future purposes, can I email your staff directly with courtesy copies?
Yes.
All right. Is there an email I can send to?
You can send it to my assistant, Jennifer. It's J O'Rourke, OROURKE at Otsego County MI.gov, all lowercase.
Thank you, Your Honor. Thank you, everyone.
Okay, thank you. That's all for today. All parties are free to disconnect at this time.
Thanks.
See
you guys.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes the court's afternoon docket. The court will be in recess until 9 a.m.